Let's talk about it.
Well, this is what we've been waiting on. The Supreme Court today denied the petition for leave to the appeal in the above entitled cause. Yes, we are talking about the state of Illinois versus Quadajah Johnson, aka Holly. I just want to bring up the appeal just to show you that they did deny it. Get that up here. Hopefully you can see that. I can try to zoom it in a little bit here.
Where real people share real stories. And no secret is too heavy to carry alone.
As you can see, the Supreme Court today denied the petition for leave, which is the PLA.
Let's talk about it.
Okay? So, let's talk about it a little bit here.
Welcome.
It's still not over. That doesn't mean the case is over, okay? People, it does not mean that. The case is not over by far. It's just that the Illinois Supreme Court refused to take a look at the case. And they will not review the appellate court's ruling, and the appellate court decision now stands.
Welcome.
Okay. Now, the filing does state that the mandate of the court will issue to the appellate court on July 16, 2026. So, does that mean Holly will stay put until July 16, 2026? It's a possibility she can. It's a possibility her lawyer might try to fight to get her out early. But usually the mandate is important because that's when the Supreme Court formally sends the case back down. Okay?
Grab your favorite drink.
So,
let's talk about it.
I'm going to try to put it like that means the Supreme Court refused to take up the appeal. The appellate court ruling stands, and the mandate is set issued July 16, 2026, officially sending the case back down to the lower court. So hope that makes sense for you guys. If not, if you have any questions, put it in the comments. I'd be sure to answer any questions you may have if I can. Okay? Now,
let's talk about it.
Let's talk about if her lawyer tries to get her out sooner. Again, it is a possibility she can try.
No secret is too,
but it's no guarantee it will happen any sooner than that mandate date of July 16, 2026. And we know Holly goes back to court on July 23rd of 2026. So within less than a week after, if she gets out on the 16th, then she'll be right back in court on the 23rd, fighting her charges, just on the outside. If she gets out, still no guarantee that she may get out. And the reason I say it's still no guarantee is because remember the state said that they're still waiting on the DNA, and it wasn't going to come back until mid-June or something like that. Well, if the state get anything new, significant new, that they can use and argue a reason to keep her in jail, like, remember when the witness said that Holly was the aggressor? She went over and she slammed down on Romeca's car as Romeca was getting into the car, probably about to leave, and she went over there and provoked her. So Holly handprint shouldn't be on Romeca's car, right? So what if it comes back and her hands are on the car, her handprints? That can mean new evidence. That's significant. That means that was no longer self-defense. It was exactly what that witness saw. That Holly was the aggressor and she went and provoked Romeca. So, I mean, any DNA, we don't know. It could come back to a point where Holly may walk out, Carlos may go in. We don't know. And this is just me, my opinion and my opinion only. I'm speaking of what can happen. And if that's the case, that her DNA come back with something significant, the state absolutely can try to use it and argue she remains dangerous. The self-defense narrative it has weakened, and the condition of release are not enough.
No secret is too heavy to carry alone.
So, I mean, anything is possible at this point. And, for example, prosecutors can also try to use the DNA to who handles certain items, close contact evidence, the blood transfer patterns, weapon interaction, or the evidence that contradicts prior statements, right? So now realistically, whether it would be enough to keep her in jail is another question. It may not. I mean, it's an open case right now. We don't know. It can turn. It's been turning since it started, to be honest with you. It's just that right now the appellate court already ruled on the detention.
No secret is too heavy.
And the Illinois Supreme Court denied the state appeal.
Grab your favorite.
So the state definitely would need to come up with genuinely new evidence to keep her in, or change circumstances to try to reopen detention arguments in a major way. You know? And even then, the judge would still have to decide whether the DNA material changes the dangerous analyst.
No secret is too heavy to carry alone.
So anything can happen, you guys, at this point. And just keep in mind, if Holly gets out, so be it. That doesn't mean she's free. It means that she just will be fighting her charges at home than in jail. But she still have to go back and forth to court. And trust me,
no secret is too heavy to carry alone.
It ain't gonna be that easy, because I don't believe she lives in Chicago, but I remember somebody saying she may have a place in Chicago. We don't know. That would be the best bet. She better have one, because she'll be... I don't know. They said her mom lived in Wisconsin. I don't know how true that is, but my understanding, they are from Lake County. So driving from Lake County to Chicago early in the morning is no joke. The traffic is crazy. But we will see what happens. And again, if you have any questions, feel free to put them in the comments. And I'll talk to you guys real soon. Have a good evening.
Real people share real stories. And no secret is too heavy to carry alone. Grab your favorite drink. Dim the lights. Pour that drink. It's candlelight and confessions with milk. Late night vibes, city lights glowing. Truth in the air, yeah, you already know it. No judgment here, just honesty. Heartfelt stories, real transparency. We talk love, we talk pain. We talk things they scared to say. If it's heavy on your mind tonight, come sit with me, it'll be alright. Candles flicker.